everybody, and welcome to episode 4 of the Unhitching Hour, how the law works when your relationship doesn't. I am Reed Aronson. I am a divorce lawyer here in Manhattan, and this is my lovely wife, Vanessa.
Hi, I'm Vanessa Aronson. I am not a lawyer, but I'm here to give opinions about things that I don't know anything about.
So, as I said, I'm a partner in the law firm of Aronson, Majewski, and Sloan. We're a family law dedicated, matrimonial law dedicated firm. It's what we do. What we're going to do today is we're going to talk about, for those of you who haven't been lucky enough to join us for one of the first 3 episodes, first of all, you can catch them on YouTube. But what we do here is we talk about how family law works so that people who are maybe thinking about getting married, thinking about getting divorced, having child custody issues, those sorts of things, just get a little bit of a better sense of how that works. Maybe you have a friend who's doing that, who's involved in that thing right now, that you want to be able to maybe talk to a little bit about and know what's going on. So we're being told that we're on. Hi.
What's the format?
So the format of how this works. Oh, sorry. So today's topic, I think we should talk about first. Today's topic, we're going to be talking about property. We haven't really talked about that yet. So one of the big questions that in any divorce case is what property is marital, meaning gets split up at the end of during a divorce between the parties in some shape, manner, or form, or what property is separate. In other words, belongs to one party, they get to keep it and walk away with it, and it doesn't get split up. And this is it's a somewhat technical question, but it's important in a lot of cases. And the way that we're going to talk about this is we're going to present you with the facts of a case, of a real case that really happened. Vanessa and I are going to talk about it. She's going to give her sense. She'll ask some questions, and she'll give her sense of how she thinks it should be decided based not necessarily on the law, but maybe on her sense of fairness, her sense of right and wrong, her just common sense. And we'll talk about it. I'll then explain how the court actually went about and decided the case. We'll talk a little bit about it, and we'll wrap up, and then we'll have another episode next week.
And I haven't, in any of these cases, I haven't yet learned any of the facts of the case.
We have not talked about any of the facts.
I'm learning it at the same time that you are.
So
hence my trusty notebook.
We also are experimenting with this little thing in the back here, just so you can remember what the topic is. If you have any feedback on whether this is legible, this is a thing that you want to keep, let me know. Anyway, if you ever have a question, you can ask it on Facebook Live. We'll be responding as we go. And if you ever have a topic that you want, if you look in the corner of your screen, Reed Aronson so if you go to unhitchinghour@gmail.com, send an email there. We can maybe do a future topic or answer a question if you'd rather not ask on Facebook Live. So with that said, without further ado, let's go to the facts of the case while Gilda is happily barking.
This week's case is called Malacuso v. Malacuso. It's from upstate New York in 2015. Andrew owns a house. Well, not really a house, so much as a piece of land with a frame of a house on it. He gets married to Claudia, and Claudia tells him, I'll help you build this house and we'll make it a home together. And that's what they do. It takes them about 4 years of hard work, but they eventually build their dream home. And they live in it until, unfortunately, they decide to get divorced. And the question facing the divorce court is, does Claudia get an equal share of the value of the house? Andrew says she shouldn't. In fact, he owned the house before they got married. He never put it into joint names. It should just be his house. And the fact that Claudia got to live there for some time, well, that's good for her, but she doesn't get any money. Claudia says, look, I did so much of the work. I should get some of the value of it. It all happened during the marriage, and there wouldn't be a house without me. The judge thinks about it, and he decides, you know what? I'll give Andrew $10,000 based on the fact that he owns something before they were married, but the rest should get split 50-50. Andrew doesn't like that, so he decides that he's going to appeal, and that's where we find ourselves now.
All right. So, stop the share. Okay, so basic recap of the facts. He owns a piece of property with a shell of a house on it. That he gets married then to Claudia. He and Claudia work together to build this house from basically a frame. Some point later down the line, they get divorced. He thinks I should keep it because it was mine to begin with. She thinks she should get some large portion of it, maybe half. Trial court says, all right, I'm going to give him $10,000 plus, and then we'll split the rest of it 50-50.
Right.
And he appeals. So what do you think?
Well, my first question, actually, I just wanted to ask those who are watching live if they could hear the video. Do you know if
I put on share computer sound, so if you couldn't, let me know.
Should be good. But we'll monitor the comments while I think through the facts of the case right now. Okay, so it's interesting that you gave me what the initial court said, because I don't know. While I want to say that I would be really thinking about Claudia and Claudia's future, I think in my head, the way I initially broke it down wasn't as generous as the initial court ruling. Because I was thinking, okay, well, he had the property and the frame or foundation or whatever before Claudia was involved. That if you can pull apart the value of the house so that you could estimate what the value was then, what that value was of just the land and the foundation or frame or whatever it was of the house. And then if you could tease apart the restoration or renovation or whatever, I'm thinking of when you watch Love It or List It, they do that, right? They're like, this was the value of the house before the renovation. This is the value of the house now. If you could tease that out, that I have no doubt that Claudia should at the very least get half of the difference of, what the value has now become of the house. Like that in my mind is like so clear that she at the very, very least should get that. Then I wonder a little bit if there's some more intangibles about, running a house, maintaining a house that maybe should be part of that, right? A house accrues interest over time, right? And potentially without Claudia there, could Claudia argue that her being at the house allowed it to continue to accrue that interest, even separate from just we redid the kitchen or we put in new floors? Like, is there a way that she could be entitled to a part of the interest that the house has accrued in the time that she was living there? So I think that's sort of what my ruling is, but that I'm pretty sure means she would have gotten a lot less. Like, I'm pretty sure that the value of the land and whatever structure of the house was more than $10,000. So I'm apparently not as generous as the judge.
Let me ask you a couple of questions. Tweak it a little bit. What if, so you said, look, take sort of what it was worth then, and then what it was worth now, and then figure out what if we just don't know, right? You have a trial. Remember, you have a trial. It's up to the parties to present evidence to the court. What if we just don't know, and we're sort of left with, well, we've got this thing. It's worth some amount of money. They can put it on the market and sell it, but we don't really know what it used to be worth. We don't really know how much it's appreciated yet until we sell it. What do you think? What do you think should happen
then? I think the burden of proving that it was worth something before Claudia was involved should be on Andrew.
Okay.
And if he didn't do his homework and he showed up in court and is like, I don't know what it was worth before, but it was worth something, well, then I think that's his fault.
So you think he's responsible for coming in and saying, I own this piece of property on day one of our marriage, and on day one, here's a Street Easy listing or a whatever, and it was worth this.
Well,
so I got an appraisal that day.
That's what I'm assuming he's arguing here, right? Is that like this should be mine because I brought it into the marriage. So therefore, I think the burden should be on him to prove that there was value already there. Like, I'm assuming we also know what the value is now. You say, let's pretend we don't know what the value is. at the very least, we got to at least know what the value is now, right? Okay.
Yeah, I mean,
so
we
know
always
what the
sell
value
it,
is now, and they're married, and there wasn't a prenup, I'm assuming, to say that the house is only his. So I think that that's marital property. I think.
Okay,
but wait, let me finish. Sorry. So therefore, 50-50, unless Andrew can prove that this was some separate like asset that he brought in. So if he can't prove that what it's worth, then I think that's his fault.
Well, what if let's say it's two things. So let's say that rather than like a shell of a house, which is what happened in this case, it's a nice little house. They've got a nice. Right. He's got a nice little house. He knows it's worth $150,000. I'm making up numbers. So he knows it's worth $150,000. And they get married, and 10 years later, they do a renovation. That's a nice little renovation, but not necessarily the whole thing. And then on the day they get divorced, they get an appraisal, and the whole thing is now worth $400,000.
Okay.
Does she get all of the 250? Does he get some portion of all of the $250,000? Does she only get some bit? Like, do you think that all of the difference between the 150 it started at and the 400 that it ended at should be in the pot, or only part?
I think automatically all of it should be in the pot. That would be split separately, unless they could make some sort of argument that like she handcrafted the entire thing herself and had documented like.
I mean the addition, the 250 that.
Right. That's what I'm saying.
Okay.
So I think the automatic should be this was value that was added during the course of the marriage. So it should be marital value or marital property, unless they somehow could argue that like I put every single stair personally and he didn't want it, or I don't know. That seems crazy, but yes, is my answer.
All right. And what if she had nothing to do with it? What if he owned a house in California, mm-hmm. and they lived in New York, and he rented out that house, and he kept all that money. He used the rental proceeds to maintain the house, and it grew in value because that's what houses often do. Not always, unfortunately, but sometimes, most of the time. And he said, "Oh, I'm done." But she didn't have anything to do with it. They never lived there together. It was just a thing that lived there, and it grew in value. Should she get some portion of the growth?
Again, I think the sort of neutral or automatic ruling would be that they would split 50-50 whatever the growth was, unless one party or the other can make a really strong argument why they deserve more than the other. And we have a few questions.
See some of the questions?
Okay, so we have a question here. Were both parties agreed that the house would be sold? Or was this a situation in which one party wanted to keep and live in the house and the other party wanted it to be sold and split the money? Yeah, I feel like that, at least in movies and stuff, that's what we see a lot, right?
Yeah, that's an interesting question. I don't actually know the answer to that, unfortunately. I think for the purposes of answering the question, I think what we can assume that either they would sell it and they would split the proceeds in some way, or even if they would not do that, even if one would keep it, there was enough money total in the pot for one of them to keep it and then to give the other one enough of a credit with other stuff.
Buy it out.
Basically, right? Buy them out, right? So it's not a situation where this is by far the largest asset and they have to sell it in order to have enough money for everybody to be made whole.
I mean, on that topic, the question is, so do judges rule differently when there is a situation that one party wants to stay in the home and the other party, like, does that sway the judge at all?
So one of the things I think we'll get to more deeply in future episodes is that when you're talking about sort of, we figured out what's marital, which we're still doing here, right?
Right.
We figured out what's marital. How it gets distributed is really very much up to the sense of fairness and equitable, right? In New York, it's called equitable distribution, and that's the same in New Jersey, same in a lot of places. It's called equitable distribution, and that means fair, right? What's fair? And let's say you have a situation where you've got a stay-at-home dad, right, who doesn't work and who spends most of the time taking care of the kids, and and the kids are still young, and this is the house that they thought they were going to be in, right? You're going to say, look, it makes sense to keep him in that house with the kids for some period of time, maybe not forever, but for some period of time, right? You look at it on a sort of a holistic basis. Whereas it's, let's say that you've got, two older people who, both of them, the kids are way out of the house and they're living on their own. And you really need to sell this asset because they don't have enough money otherwise, then you'd say, okay, we're going to sell it. And that's what's going to happen. And it's really very much up to the discretion of the judge.
I guess, though, at the heart of the question is sort of like, could that be a strategy to sort of win favor with the judge? Could you make it seem like you want to stay in the home and then turn around and sell it?
Look,
would that give you any advantage?
It could. I mean, it definitely could. It definitely could. And the fact of the matter is that once there's an order, there's not an order that's going to say, and you have to live there forever, right? Or you have to live there for some period of time. Usually it's just going to be, all right, she gets the house or he gets the house, and then what he does with it or she does with it is up to them.
Okay. Are we ready to share I was going to ask us if we could go back to the slide before we share.
Sure. Why don't we go back quick to the slide? So we're going to go back to the slide.
One more time.
So basically,
move the mouse.
Sorry. So where we are is, we're on appeal. He owned it before the marriage. It was a shell of a place. It wasn't a full house. It was just a piece of land with some framing. After they got married, they both worked together to build it up. The judge ultimately decided to give him $10,000, in effect reflecting what he owned before, and then the rest split 50-50, but he appeals. Okay? So stop the share. So here's what the appeals court does. The appeals court reverses the trial court and gives the entire asset to Andrew.
The entire thing?
Yes, and says it's separate. And here's why. So the general rule, and there are exceptions and other things, but anything you have before the marriage is yours. Anything that you acquire through work or effort that you do after the marriage is marital. Mm-hmm. Okay? Here, there's no question. He owned this before the marriage.
Right.
And if there is passive appreciation, right? And by passive, I mean not due to your work, right? If I own a share of stock in General Motors, and I hold on to that share of stock, and it goes up and it goes down and it goes up, it has nothing to do with what I did, right? It has nothing to do with my efforts, right? The fact that I own this piece of this share of stock, it's the market, it's the universe, it's other people who are not me or my wife. But right, so
that would be passive.
So that would be passive. On the other hand, if you own something and you work on it actively and you put an active effort during the marriage.
So like creating a business?
Like creating a business. So let's say that I open up a deli, right? 2 weeks before we get married.
Okay.
And I've got a deli, and I've got this deli and this business. And over time, over the course of the marriage, I work there every day and I spend all my day there and, 10 hours a day putting in blood, sweat, and tears. And I have a wife who comes in and she also works at the deli. The appreciation on that is due to my efforts during the marriage and should be marital. So the question is then figuring out, which I think you hit the nail on, what was it? So sort of two questions, right? What was it worth the day they got married?
Okay.
How much did it, or I guess three questions. How much did it grow?
Right.
And how much was that growth due to the active efforts of the married couple, as opposed to just what happens in the market?
Okay.
Okay. And what the appeals court says is that Claudia didn't prove what the appreciation was as a result of the active efforts. That was her burden of proof, and she didn't do it. And since she didn't make that showing, all they can do is say, well, it was his on day one, it's his now.
So that's interesting because I put the burden of proof on I put like a higher standard on the marital property part and put the burden of proof on Andrew to prove what it was worth when they came in. And the appeals court did the opposite. It put the higher value or the higher whatever on what he brought into the marriage and made the burden of proof up to
so
what's her name? Claudia.
So the initial burden was on Andrew, right? He had to, in the initial step, show that this was his separate property. But once he did that, and she then wanted to say, no, it was actually due to all this work that I did and all this work that he did while we were married, then it was on her.
Okay.
Right.
So I did see a question come in, and it's frankly the same question I had, is like, what the heck was wrong with her lawyer? The actual question is, so Claudia had a crap lawyer. Like, do you know who the burden of proof is on at a given time?
I'm not gonna speak to crap lawyers. I don't know enough about the case. I'm not gonna talk about that.
Well, but do you, when you go into a case, do you have an understanding of like, okay, because of the way the law is framed, it is our burden to prove X, Y, Z.
100%. You have to know, if you're going to go to a trial, you have to know what you have to prove and what facts you have to prove it, right? Let's say we're talking about the deli again, right? And we've got to prove what this deli's worth. I can't just be, as a lawyer, going, well, so I think it's worth $1 million, and I say that based on my lifetime of expertise. No, you need somebody who knows what they're talking about. You need somebody who knows how to value things like that. You need, if you're talking about real estate, right? Like let's say we're trying to figure out what a piece of property is worth. You need to give the court, whether it's the trial court or the appeals court, you need to give them facts. And facts could be, sometimes facts are an opinion, right? An appraisal's an opinion, but it's still facts from somebody who could opine on it effectively. And she just didn't do that. At least what the Court of Appeals said, or the appellate division said, that she didn't make that showing, and she needed to.
And it's interesting because I feel like right now I'm learning what you do, because I've heard you use these terms before, like that's one of the things that you specialize in, and I don't think I understood what that meant. So you would have done a better job though, right? So in this case, her lawyer just didn't substantiate her own claim.
No.
Is that correct?
That's basically what the appeals
court said. That's a big word,
now,
substantiate.
Look, to be fair to the lawyer, and I don't remember who the lawyers were on that side. They won a lot of there were a lot of other things going on in this case. There were stock portfolios that he had contributed marital money into and things like that, and they won a lot of those claims.
So it might be a point at which you have a lot of different battles that you need to focus on, and you have to be strategic about which ones you're going to. And look,
sometimes you think something is easier maybe than you thought it was. Look, they won at trial, right? So obviously they didn't do nothing. They won at trial, and they got the judge at trial to give them a pretty good result.
So that's another question. I guess I didn't realize. I mean, it makes sense, but how often do divorce, I want to say settlements, but it's not a settlement, divorce decisions go into appeal? Like, is that a realistic option? If someone
I don't know the percentage.
Unsatisfied with their divorce decision, like, how do they know if they should pursue an appeal?
In my experience, trials to a conclusion are very rare. They are in the single digits percentages of cases that happen. Now, a lot of cases get to trial, and you settle what's called on the steps of the courthouse. But the vast majority of cases don't get to this point. So, the point where you get there and then you get to an appeal
would be even smaller.
It's even smaller. But on the other hand, if you're that committed, right? If you've spent this much time and effort and like I said, blood, sweat, and tears going through a trial, and you say, look, we got to try an appeal. We got to, we didn't get the way we wanted. We've got to fight about it. So I don't know. I can't tell you the percentages. And obviously it would be hard to compile that.
but it would be a very, very small percentage.
In terms of this point where you're through a trial and then you're appealing the final result of trial, it's a very small percentage. Now they end up being big cases, right? Because you're not going to go that far generally unless there's a lot at stake.
Right. Here's another question that we have. Once the non-owner spouse, so that would be in this case Claudia, proves that the increase in value was at least to some extent active, who then has the burden to prove how much of that increase was active?
I wonder how much that was. It would be again, it depends on what you've proven, right? If all you said is some portion of it, then the burden would be on you to show how much of a portion. But if you say, like in this case, I think if she could have shown that a substantial portion of the appreciation was marital, I think then it would have been on Andrew to turn around and say, oh no, but let me show you what happened in the market, right? So let's say he had a plot of land.
So
right?
it's okay.
So in this, like I said, in this case, she did a lot, and it was probably the majority of it was active, right? It was because of the effort they put in, but she didn't show any, so therefore she lost. But if she had made a showing and said, look, here's where it was on day one, and here's where it is on day two, and let me bring in a real estate agent who will testify and say, oh, well, because they did this and because they did that and because of this other thing, that would have been a very significant cause of the appreciation. It would have been then on Andrew to come back and say, okay, maybe it would have been a lot, but let me show you what happened with just the land prices.
Right.
For example, I can show you there was a plot of land right next to it that never got developed, and that went up as much or more than our property did. So therefore, it
was passive.
It ends up becoming sort of a back and forth waiting issue.
Very, very interesting. But I am seeing sort of flashes of Love It or List It, the TV show on here. I think they'd be pretty good at it.
Yeah.
I think they'd be pretty good at that. Well, I think we've gotten through all of the questions that have come in on Facebook Live. Shall we give it just another minute? Why don't we, while we see if there's any other questions, how do people who are watching share their ideas for upcoming episodes?
So I spoke about this at the beginning. If you look at the corner right there, I think, if I'm pointing right, I'm always confused about whether the camera goes backwards.
Point the other
this
way.
Okay, this way. It's the email of the show, unhitchinghour@gmail.com. Up on the screen, you can send emails. I'd love your ideas for future episodes. You can also comment on our Facebook Live page. It's my Facebook page, but Reed Aronson, and we're checking Facebook comments.
What if someone has tuned in, but they only got half the episode? Where can they find the whole episode? They can
find it on YouTube, and if you'd like to go, you could. I think also, first of all, you can still find it on Facebook even after we're done. But you can always check on YouTube. Unhitching Hour is our YouTube channel. They go up. I try and get them up soon. It takes me a little bit because I'm not great with video editing, but they go up on our YouTube page. All three of our first 3 episodes are up on our YouTube page. So please go like, subscribe on that channel, like this video, share it, please, and that'll be.
Our only last comment is an ask for an encore, because last week we did go over 2 cases, but this week we only are doing
one case.
Sorry. You'll have to wait with bated breath for next week.
Yeah. All right.
So
thank you all for joining us. That was the Unhitching Hour. I am Reed Aronson.
I'm Vanessa Aronson.
And I hope you'll join us next time.
And why, Reed Aronson, should they be listening to you?
They should be listening to me because I'm a Manhattan divorce lawyer. This is what I do. And I'm trying to hopefully educate people as to how the law works. How the law works when their relationship doesn't.
Great. All right.
Thanks, everybody. Have a great one.